0553 Contreras Farms Limited LLC versus City of Phoenix et al. Council, I would alert you to a couple things. This oral argument will be audio and video recorded and actually should be up on YouTube in a few days, so you can go back and look at that again if you'd like. But also, so please identify yourselves and your clients at the beginning of your arguments. Each of you will have 20 minutes, or each side will have 20 minutes. Appellant's counsel, you're responsible to watch the clock and reserve as much time as you would like for a rebuttal, if desired. And also, please keep in mind that we've read the briefs, we're familiar with the basic facts and procedure of the case, and we've also discussed it this morning in conference. With that, counsel for appellant, you may proceed.
Thank you. May it please the court, my name is Christina Reeves, and I represent the appellant Contreras Farms. Contreras Farms has a statutory right to an exaction review hearing, but they have never had their hearing. Arizona law provides them with the right to have the exaction that Phoenix imposed upon them reviewed at an exaction review hearing, but they have been denied this right. We're asking this court to fix this. We're asking this court to reverse the lower court's grant of summary judgment in Phoenix's favor and allow Contreras Farms to finally have the exaction review hearing that they have been denied. We are asking this court to give Contreras Farms the opportunity to exercise their right and to finally have their say. This case arose when Contreras Farms built a school. The question in this case is whether the city of Phoenix, when Contreras Farms built that school, exercised any discretion when it determined whether or not Contreras Farms had to install a water main extension, when it determined...
Let's stop right there.
Yes, Your Honor.
Your phrase, the terminology, as Judge Jones said, I think terminology means a lot, especially in this case. Is it whether the city of Phoenix actually exercised some discretion, or is it whether the city code provision actually allows for discretion? What's the legal issue before us?
Under the statute, Contreras Farms was entitled to a hearing if under the code the city could exercise discretion, not whether or not...
Regardless of whether they did or not.
Regardless of whether or not they exercised any discretion. If they had the ability to exercise discretion, as this court found in American Furniture v. Gilbert, then the property owner was entitled to an exaction review hearing under the statute. And here the city of Phoenix had discretion when it determined the nature and extent of the exaction. It had discretion when it determined whether or not they had to install a water main extension at all, when they determined where it had to go, when they determined how long it had to be, when they determined whether or not it had to be looped, when they determined how large it had to be. The city of Phoenix exercised discretion in making all of those decisions.
But isn't the language of the requirement written in terms of shall?
Under the code...
Contreras Farms shall do what they were being told to do?
Yes, the developer shall, that is what the code says, but they shall install the water infrastructure in accordance with plans approved by the Planning and Development Director. And it's in accordance with the plans approved by the Planning and Development Director that allows for the exercise of discretion. For example, in this case, under the code says that the developer shall install water infrastructure on the streets bounding the entire development. That's the code. Here there were two streets bounding the development, Baseline Road and 43rd Avenue. Phoenix only required them to install water infrastructure on one of those streets, on 43rd Avenue. They exercised their discretion to not require any water infrastructure on Baseline Avenue. Of course, it wouldn't have made sense for them to have required any water infrastructure on Baseline Avenue because there already was a water main and no water infrastructure was needed. But under the code, the code does not allow for them to exercise that if you take Phoenix's interpretation of the code, but it does because it allows the Planning and Development Director to make those determinations. And when you read the the code in an overall context. In 3732, which is the code right before 3733, it says that the Planning and Development Director is responsible for determining the needs of water infrastructure under 3733. So Phoenix's argument that the Planning and Development Director has no discretion when under 3732 he's required to exercise discretion and determine the water needs does not make any sense.
Doesn't the issue, the portion that you're talking about, the placement of the line is mandatory. It's up to the appropriate city official to exercise discretion in regard to the size of the pipe, the location of valving or whatever as it's built. There are different needs in different areas depending on the street that it's being run down, right?
Exactly, and
so
that
the condition of the piping, or the condition, I'm not reaching for a word and I can't get it. The necessity of that particular line is where there's discretion. There shall be a pipe put in.
yes.
And how it's going to look and how it's going to be limited, it creates a redundancy in regard to water availability in the streets, right? I'm
sure City of Phoenix has it. I mean, City of Phoenix has its reason for requiring water infrastructure, I'm sure.
And this does assist that reason, what they're asking for. The engineering of that line and the component parts of that line and where it's going to be placed is where the city has some discretion, correct?
Yes, the city has some discretion, and under the code, it's not that if the city has discretion, only if the city has discretion in determining whether or not a water main extension has to be installed at all. If they have no discretion on that, then the Contreras Farms isn't entitled to a hearing. That's not what the statute says. The statute says if there's any discretion exercised by the city of town as to the nature or extent of the exaction.
Let's break that down, because I have a feeling it might tend to lead to some absurd results. You're saying that even down to the engineer's determination, say the city engineer and the developer's engineer can't agree or they're having a disagreement over the type of piping. I mean, one wants concrete pipe, and I don't even know what kinds of pipe are available these days. PVC, concrete. I don't think they're going to put clay pipes in the ground anymore, but whatever types of pipe, you're saying that you'd be entitled to an exaction hearing on the type of pipe. If the type of pipe was not to the developer's liking, then you'd be entitled to a proportionality hearing on that sole issue.
The statute says very clearly that if there's any discretion exercised by the city or town as to the nature or extent of the exaction, then the property owner is entitled to a hearing.
But a hearing as to what? In my example, in my hypothetical, you would have a hearing only on the size, only on the type of pipe. You wouldn't have a hearing on the overall requirement that there be a main.
You would, because
how would you get there?
Because the statute says that the purpose of the hearing, at the hearing, what is the hearing officer is required to decide is whether or not there's an essential nexus between the exaction and the purpose that the city is saying is being served by the exaction, and whether or not there's a rough proportionality. Essential nexus with the exaction and rough proportionality would necessarily involve the consideration of the entire exaction, not just one little tiny thing about it.
Council, can it be an exaction if it's statute or code or in a municipality, if it's in whatever, if it's mandated by code or statute, can it be an exaction?
It can be an exaction, but under the statute, if there's no discretion, if it's absolutely mandated and the city doesn't have any discretion in determining it, then the property owner isn't entitled to a hearing. It's still an exaction, but it's just they're not entitled to a hearing under the statute.
I mean, would you agree that every developer who constructs a development, that's the owner of land who constructs a development other than a single family home on a single lot, has to install a main on the street where the streets bound the property?
I don't, and in the record it shows that there is another property that was very similar to Contreras' Farms property. It was on Baseline Road and 27th Avenue, and the developer developed that property, and for that property, the city waived a requirement for the developer to install any water infrastructure at all,
I
even though
saw
there.
that in the record, but I didn't see that re-urged on appeal. I may have missed that, but that's, okay, assume that's true. But I thought we were talking about here what the code actually provides for, and not whether the city has actually, I mean, I guess what I'm saying is it doesn't matter. The facts don't matter here. The facts don't matter here because we're looking at only words on a page. And it doesn't matter if the city waived in a different instance. Because we said we're only going to focus on the language of the code and
Yes.
compare it to the language of state statute.
Exactly, but when we look at the code, we're trying to decide what is the most reasonable interpretation of the code and whether or not under a reasonable interpretation of the code, it allows for the exercise of discretion for the city. And the fact that the city in a previous case interpreted the code as allowing for it to exercise discretion causing to doubt the reasonableness of its claim now that it has no discretion. And in the facts of this case itself demonstrate, I'm sorry, Your Honor.
Does that change the outcome? If they required you to do it, and it's mandated that it be done, does it change the case here that they may have deviated from that somewhere else?
It doesn't change the application of the statute. It just calls into question the reasonableness of an interpretation that there was no discretion. Like example, in this case, when the City of Phoenix first submitted their plans and said that they weren't going to install any water infrastructure, and the City of Phoenix commented on those plans, they said, we want you to install a 12-inch main extension that's going to go from Baseline Road to your south property line. And when Contreras Farms got those comments, they called a City of Phoenix official, Kelly Boyce, and said, this extension's not going to serve the school at all, so we don't think we should have to install it. Kelly Boyce, who is a Phoenix official responsible for administering this code, he thought he had discretion under the code, and he told the City of Phoenix that he would waive that requirement and they wouldn't have to install it. And then 2 months later, in an exercise of their discretion, they changed their mind and said, no, you know what, we're going to have you install it after all. And the City of Phoenix said, well, what can we do about it? Because we really don't want to have to install this. And
Well,
then
yeah,
another.
undoubtedly, there's some clumsy, I mean, at best, clumsy language used or representations by the city, if not outright, perhaps misrepresentations. If they're not allowed to deviate, then I don't know why the city suggested that, that. Yeah, I know there was a memo written or something to the effect that it could be waived if you squinted a lot and looked at it, and if the manager or whoever was over this going to make this determination, if they could come up with a reason why the intent might be different. Yeah, but again, I go back to let's focus on the plain language here, and what is the most reasonable interpretation? Again, we're looking for the most reasonable interpretation of this code provision.
Well, looking at just the language of the code, you can see that there is an exercise of discretion because under the code, it says for non-residential developments, like a school here, the minimum size of a main is to be 6 inches, but it can be larger if needed. That it requires a minimum, but allows for an exercise of discretion to require a larger main if needed, allows for the city to exercise discretion. And they exercised it here because they required Contreras Farms, a non-residential developer, to install a 12-inch main, which was twice the minimum that was required under the code.
Did you press that argument in the Superior Court? I know you weren't counsel. I don't believe in the Superior Court, but was that argument pressed in the Superior Court?
The argument that was pressed in the Superior Court is that the city exercised discretion and that Contreras Farms was entitled to a hearing. The fact that they exercised discretion as to this one area, I believe it was brought up during the hearing, but I don't think it was pressed in the actual motions for summary judgment or responses to the motions for summary judgment, no. For those motions and the responses thereto and the court's decision, pretty much focused on a Nolan-Dolan analysis rather than an analysis under the statute.
Okay.
Let's talk about, just for a second, 3733A. Let's get the language right out there. How's that? So we know what it is we're dealing with. In all new subdivisions and single lot developments, and all other developments other than a single residence on a single lot where the city is to provide water service. The developer shall furnish and install in accordance with plans approved by the Planning and Development Director all water mains within the boundary of the development as well as the streets bounding the entire development.
Yes.
Sounds pretty thorough,
It,
complete, and mandatory.
it does, except that the fact that the plans have to be approved by the Planning and Development
I'm
Director,
sorry, that they have to be
approved by the Planning and Development Director, and 3732 says the Planning and Development Director, when determining the water needs under water infrastructure needs under 3733, is supposed to, when determine what water infrastructure is needed, is supposed to determine what the needs of the city are. So he's vested with that discretion to only require the water infrastructure that the city needs, and to not require infrastructure like a water main on Baseline Road where there already is one that the city does not need. Now, the next,
Is that the case, or is it a case of the engineers being able to decide where valves are going to go, and where turns are going to need to be made, and where maybe there's something in the soil that's going to be required to have it shielded or something? Isn't that where the deviation is allowed, as opposed to the shall install becoming we may and may not install?
that may be seen, but the facts of this case demonstrate that that's not a reasonable interpretation of the code, because here it says that they shall install this water infrastructure on all the streets bounding the development.
Right.
But they didn't, City of Phoenix did not require any water main infrastructure to be installed on Baseline Road. And the next sentence
Baseline
says,
Road already has water.
exactly.
Wouldn't that be an absurd reading, council? I mean, if to say that you need to, that's like saying you need to pave a road again that's already paved. If it says you shall pave the road, all roads must be paved. You're not suggesting that a developer would have to go repave the road that's already there.
Exactly. It would be a ridiculous interpretation, but that is Phoenix's interpretation. Their interpretation is they have no discretion. It says that there has to be water main infrastructure on all the streets bounding
But there
the
already
development.
is on Baseline.
Exactly. So it doesn't make any sense that there's no discretion in the code, because it would require the installation of water infrastructure when it's not needed.
But there was not water main on the road that they put the
43rd.
on 43rd adjacent to your client's property.
There wasn't, and so the city exercised its discretion to require a 12-inch main there. If you look at the next language, it says the developer shall, again uses that shall language, shall furnish and install water mains necessary to create a looped connection. Here, as City of Phoenix concedes, they didn't require Contreras Farms to
Did it say
install
as
water
needed?
mains. I'm sorry?
Didn't it say as needed?
No, it does not say as needed. Oh, yeah, as necessary to complete a loop connection. So you have to install what water mains would be needed to create a looped connection. Here, they didn't require the water mains that were necessary to create a loop connection to be installed. They just required the one water main on the 43rd Avenue. They didn't require water mains to go around the entire property and create a looped connection. So, and that is the same language, the developer shall, but there's discretion. And I'd like to reserve the remainder of my time for rebuttal. Thank you.
Thank you, council.
Good morning, Your Honors. I'm Daryl Manhart. I represent the City of Phoenix and the city employees Kelso and Prieto. Co-counsel from the trial court is here with me today as well. Their first argument in their brief, their argument in their brief is that there was discretion allowed in Code Section 37-33. The language, as the court has pointed out, is shall. That's mandatory language. The argument here today has frequently been taking as a premise that various things represent the exercise of discretion, and I would dispute the premise of that statement. The requirement...
So it is discretionary to do certain things beyond the placement of the pipe and meeting the mandate that's put on the owner of the property at the time of construction, isn't it?
Perhaps so.
If they needed to put some kind of a modified valve, if they needed to put some kind of protection around the pipe to keep it from crushing or scarring, I mean, you wouldn't have to say, we've got a standard way of doing it, and you're all going to do it the same, even though you're all going to have different situations that you do it. So wouldn't you allow it?
Well, Your Honor, you're accurate in that in any given situation, there may be something that's different from one site than another.
Can they deviate in order to make that difference function?
Well, I want to avoid not answering your question. The context here is in respect to the proportionality appeal statute. So back to your question, there might be some discretion exercised, and I don't even know if I want to call it discretion, but a decision made as to what's needed in a given situation. But the challenge by the plaintiff, Contreras Farms, is that the discretion exercised here applies with respect to Arizona Revised Statutes 9-500.12, which is a proportionality appeal statute. So that statute incorporates the Nolan-Dolan analysis on nexus and rough proportionality. So the fact that there might be a valve required, for instance, isn't the same as the challenge being made here, which is they want to avoid the requirement that they install a water main at all. And so the question would be, when you talk about the nature and extent language in 9-500.12, excuse me, whether you're talking about some discretion exercised as to whether you put in a pipe at all, who puts in the pipe, how much pipe's put in, and there's no discretion in that regard with respect to 37-33. It's the boundary of the property, and it's a water main in the underlying street bounding the property. So if that required some particular connector valve at one end or the other, that's not a proportionality issue.
Let's stop right there for a second.
Certainly, Your Honor.
9-500.12, as Ms. Reeves suggested, it just says that does not, the language, it does not give discretion to the administrative agency or official. It doesn't say minimal discretion, maximum discretion, a lot of discretion. It says nothing about that word discretion.
It says nature and extent, Your Honor, in the section you're looking at.
To the exaction, okay, discretion, true, but what does that mean? Nature and extent, that could be 12-inch to 10-inch to the type of pipe. Why? The nature and extent of what?
Well, Your Honor, other code sections can apply too. In fact, this particular code section also does discuss 12-inch mains in arterial streets. And the record shows the testimony of Brandy Kelso, which is in the record, confirms that there was a 12-inch main in Baseline Road and a 12-inch main in the former 43rd Avenue.
With the court, you wouldn't dispute that the city could have allowed a 6-inch main here.
I don't believe that's correct, Your Honor. I understand what the plaintiff's argument is, but that would be inconsistent with what's in use in the surrounding area.
I'm talking about just on the code. The code says non-residential is 6-inch.
It says a minimum, I believe.
Minimum 6-inch.
Yes. But, Your Honor, there was no issue raised here by the plaintiff as to whether they wanted to put in a smaller pipe. The only issue asserted was we don't want to put in a water main at all. And the argument also wasn't made based upon proportionality. It was based upon the argument that we can tap into the water main in Baseline Road. We don't even want to tap into one on 43rd Avenue, so please let us not put one in. There was no argument made as to proportionality until months later after the water main's already installed.
Understood. But now it's before us. I mean, as far as proportionality.
It is, Your Honor. Well, it's before you if you ignore other issues that I've raised as cross issues too. But as far as sticking with plaintiff's issue, it's not a I dispute that it's a discretionary issue as to whether they were required to install a water main. And the fact that they can now, in hindsight, point back and say, well, maybe we could have argued to install a smaller one is not consistent with the record that was made.
So what is the exaction here? Can you explain to me in your own words, what it precisely is the exaction?
Well, Your Honor, In my brief.
Alleged exaction.
Exactly.
Yeah,
That is
okay.
the phrase I use in the brief, alleged exaction, and I will concede we have not made an issue on appeal, and did not argue, I should say, we've not made an issue on appeal whether it's not an exaction, but I do call it an alleged exaction because if you look at that, it is covered in the briefs filed on both sides in the lower court. According to Black's Law Dictionary and referring to land use exactions, it generally refers to a dedication of land or a payment of a fee, and the payment of fees in the proportionality context refer to intensity of use. There's just no issue about that here. This is not like a development fee under the statute that they also cite on appeal, ARS 9-463.05, which are development impact fees. Those are based on intensity of use. That's not what is at issue here. So when you say what's an exaction, that would be an exaction. The American Furniture case, that was an exaction. That was a sliding scale fee based upon different types of use. Retail, I'm sorry, I'm not remembering. There's about 4 categories, I think, in Gilbert's system development fee ordinance. Those are impact fees. This is an absolute requirement, not you have to install 50% of the length of a water main, or you have to install or pay for a fee toward installation of a water main. It's that if you're developing a piece of property, you have to be responsible for there being water mains in the bounding streets. It's an absolute requirement. It's a legislative determination by the city council that all development has to satisfy that. That's simply not an exaction. But I've taken a long time to say that, yes, assuming that it is, it's one here where that particular, in air quotes here, exaction is one that's simply an absolute requirement that it has to be installed. There's no nature and extent as to whether you install part of it or pay for part of it. It's that you have to install it. So when you talk about sort of, they say the length was the boundary of the property. There's no discretion there. So I dispute that there's any discretion involved in this and deny that their interpretation of the statute that somehow shall only applies to the director, not the developer, is a reasonable one.
The overall requirement to place the pipe in the ground from point A to point B, there's no discretion there. I mean, you don't, that's what your argument is. There's no discretion there. But you would agree there is some discretion with regard to the things that Judge Jones was referring to, i.e., how deep is the pipe going to be placed? What kind of pipe is it going to be placed in the ground? How many, is there going to be a valve? Is there going to be a fire hydrant attached to it? Those types of details, how would those details be resolved?
Well, Your Honor, I'm not sufficiently familiar with the Phoenix City Code to tell you whether those are all covered elsewhere. They may be. I suspect that the depth is not always uniform because topography changes and the gravity flow would dictate where that's going to be.
In specific reference to 3733, would those things, would one expect those to be included in the plans that are submitted to the water director?
Yes.
Or planning and zoning director?
That would be for approval.
Yes, those have to be approved. But it would not be to approve plans that omitted to install the water main. And that's what plaintiff's position is, that the developer could have submitted plans and that the ordinance doesn't bind the director, it only binds or only directs shall to the developer, and therefore the director somehow could have approved plans that didn't require it. So everything else is going outside of that to speculate on things that could lead to absurd results, but what we have before us is just a water main that this developer did not want to install at all.
What about the reference Ms. Reeves made regarding the waiver, if you will, or whatever, where the city excused the requirement at some point down the road a ways in another area?
The 27th Avenue example, Your Honor?
Yes, wherever it was.
Picking up on your question before, you're correct, it is not argued in their briefs at all. It is in the record below. So my first point would be that's waived. But also, if you look at it in the record below, the response to that from the city was that was a mistake. The employee who permitted that made a mistake. So the city's not bound to now when one employee makes a mistake, doesn't change the interpretation of the code section to now require every other employee to continue making the same mistake.
Do you know if that was brought up, was that in the context of the summary judgment pleading?
Yes.
That's where
Yes,
that's
it is
where
in
that
the
occurred.
summary judgment record. It is
Okay.
not in the appellate briefs. Now, I don't want to skip my other arguments here, which I know that plaintiff had no obligation to address them because they're all my cross issues, and I'm not sure if I can get through them all in this time. But one point is that the plaintiff argued below that it had no knowledge about the proportionality statute until months, like 11 months after the denial of its technical appeal, is when it first requested a proportionality hearing. But in the record, Exhibit 2H to plaintiff's own fact statement, there's an April 4 email to the engineer, plaintiff's engineer, the one who processed all of the requests to the city, which has several attachments, one of which is the 5-page appellate, the list of appellate procedures available, and I'm sorry, I think it's 6 pages, but on the 5th page, there are 2 different appeal procedures noted there. One's the technical appeal, and the other is the proportionality appeal. So in April 2014, they had notice of that. So the argument that they didn't have notice till months later, and that's why they didn't make a request till 2015, March 2015, is inconsistent with the record. They had knowledge of that, and the statute says, you know, the city's supposed to give that notice. The city gives a packet. They don't know that that's a proportionality challenge even being made. Plaintiff chose the technical appeal, did not choose the proportionality appeal. So if you want to debate when's the final action, when they decided not to pursue the technical appeal and submitted their plan, certainly, which was in April 2014, they know there's a final action at that point. They don't bring a proportionality appeal, they install the water main. So they don't have any compliance with the statute that they're now making their whole claim on. Another argument that they make,
Counsel,
I'm sorry, yes.
To be a little technical, did their action concede their responsibility or their obligation?
Well, I split into 2 parts. What you could debate me should have been one, which is the failure to exhaust administrative remedies and waiver. I think your point is when you say, do they concede it? I do argue that by abandoning the appeal that they had taken, submitting their plans and installing the water main is an acquiescence to the requirement, and that's a waiver of it. Even if you don't see that as a separate issue, once they have initiated the technical appeal, which had 3 stages, and they abandon it after the first stage, that's a failure to exhaust administrative remedies. And the case law is pretty clear that if you're going to sue the government for damages and you fail to exhaust your administrative remedies first, you're not entitled to any relief from the court. And that's what happened here as well. So they've either waived it or they've abandoned their administrative remedies, and that entitles them to no relief. They also...
Counsel, on your cross, let me ask even a more technical issue.
Yes.
Were each of your cross issues properly raised in the summary judgment pleadings?
Okay, I'm going to
Because you
give
know
a
where I'm going.
qualified
If you
answer.
didn't file a cross appeal,
I did not
then
file
would
a cross
consider-
appeal.
then for me personally, I would consider those waived.
Okay, and forgive me if I'm lecturing the court. A cross appeal is required if you're requesting relief that enlarges what you were awarded below. A cross issue is one that does not involve enlarging it, but is an alternate ground that supports the decision that was made. Of the 5 cross issues I raised, 4 of those are all in the summary judgment papers. The 5th one, the last one, is regarding the notice of claim statute, is in the record below, but it was raised before the summary judgment motion in a motion to dismiss. And the relief would be the same, or the ruling would be no relief for the plaintiff. So it's also an appropriate cross issue on appeal because it's not enlarging any relief. So I hope that addresses that. As far as the statute that they're relying upon here, though, I'd like to point out, among other issues that they newly raise in their appeal briefs, is they slightly change, I shouldn't say slightly, they change in their appeals the relief they're requesting and what was described here today, too. Today, they're asking you to reverse this and order that there be a proportionality or exaction appeal hearing. That was not requested below. If you look at the request for relief in the complaint, pages 14 and 15, if you look at the cross motion for summary judgment that plaintiff filed below, the conclusory page of that, I'm going to guess it's around page 15, but I'm not sure right about that right now. What they request is a declaration that the city violated the proportionality hearing statute by not having a hearing and award them compensatory damages. There is no request for a proportionality appeal hearing. There is instead an argument that the statute was violated and they're entitled to compensatory damages for it. That statute does not create any private cause of action for damages. It's an appeal procedure. The legislature has created an appellate procedure. So the relief that they're requesting now is not what was requested. And if you look through that statute, the relief that they want would not be available either. First of all, if you have a proportionality appeal hearing, the hearing officer can only do one of three things. That's delete the requirement, modify it, or affirm it. So there's no possibility for that hearing officer to award damages for having already installed something. Assuming the hearing officer...
Why couldn't they challenge the fact that they were wrongfully denied a hearing?
I'm sorry?
They weren't wrongfully... Isn't the allegation, one of the allegations, that they were wrongfully denied a hearing? I thought the city told them they couldn't have a hearing.
The city, when they...
Why couldn't they challenge that?
They can, Your Honor.
That decision.
They can, but the argument would be a special action for an order to impose or to mandate that the city have the hearing, which is what happened in American Furniture. In American Furniture, fee was paid under protest, and contemporaneously, the American Furniture, I guess, the developer requested the exaction hearing, and Gilbert refused to give one, and a special action proceeding was filed to require it to give one, and this court's order sent it back with a requirement that they have that hearing. In this case, the plaintiff argues, we didn't get a hearing, we've already installed the water main, we want compensatory damages. That's not available under that statute. And on appeal, they're not requesting that, they're changing the relief to say, give us a hearing. Well, that's waived. And if you go through the statute, then, again, the next step, if the hearing officer agrees with the claimant, in this case plaintiff, that would be the end of the matter. If the hearing officer said, I agree, this water main should not be required, they have no damage claim, they simply don't have to install it. And that's what the letter responding to their belated request says. It doesn't actually use the word time, but effectively says, you've waited till you've installed this. The only remedy that the hearing officer could give you if he agreed would be, say, disconnect the water main. What they want to argue again is, you should have to pay us for installing a water main that we argue was unnecessary. So if they won on that, they're trying to require the city to pay for what they've established would be an unnecessary water main. There's no requirement for that. If you look at the only reference to damages that occurs in the statute, it's in that last paragraph, and that's if there's an appeal from the hearing officer affirming the requirement. There's no issue here about modifying it in some way. It was either install or not install. And then the court has a certain leeway to grant injunctive relief to try to preserve the status quo. And then when it finally decides the issue, if the developer has been damaged by the delay, because it anticipates that this will all occur before satisfying the requirement or exaction, the court can award delay damages. Here, the complaint specifically pleads that they installed the water main to avoid delay. So they've admitted there's no delay damages. They're suing for compensatory damages that are not available under the statute, and they're not entitled to any relief. I'm out of time. I want to point out, though, that all of this, the lower court said this issue was plagued by legal and procedural issues on plaintiff's side and awarded us fees. It's even more plagued on appeal as they have raised new issues and request that you affirm and grant the city's appeal fees. Thank you.
Thank you, counsel. Please.
First, the issues that the City of Phoenix, right? The relief that we are requesting is a hearing. Contreras Farms complaint made very clear that what we were alleging is that the city violated the statute by improperly denying our request for a hearing. And there's not really any reasonable interpretation of our complaint or any of the actions below that we were not requesting to have a hearing. That is the request. That is the relief that would come from this city not giving us the hearing that we are entitled to, is for the city to give us the hearing that we are entitled to.
Which would lead to what? And let's say the hearing officer ruled in your favor, then what?
If the hearing officer, if the hearing officer were determined that the city was, that the exaction was not proportional, or the city had failed to meet its burden of showing that that the exaction was proportional and essential nexus and all that, the statute allows that the hearing officer could delete the exaction. And if the hearing officer deleted the exaction, then that would mean the city could just, if that exaction was deleted, then the finding would be that it was unlawfully imposed, and the relief would be to put Contreras Farms in the position it would have been in had that exaction not been unlawfully imposed.
Is there any authority for that?
The authority I would cite for that is the statute itself and this court's holding in American Furniture. In American Furniture, the exaction had already been complied with.
That's just taking a pot of money and just giving it back to American Furniture.
Yes, but the relief that's available to the property owner shouldn't depend on whether or not the exaction was installation of infrastructure or a payment of a fee. That shouldn't affect the relief that's available to the property owner. Here in American Furniture, the exaction had already been paid, and this court determined that there was discretion for the city of Gilbert on determining that travel signal fee, and remanded so that American Furniture could have a proportionality hearing that they were entitled to. And I think it's unreasonable for this court, if they would have ordered a hearing to happen, that would have been futile, that would have been unable to grant American Furniture any kind of relief. And yet American Furniture, even if this court finds that installation of the water main extension is required, that doesn't mean that the city had no discretion as to the nature and extent of that exaction. In American Furniture, this court determined that the traffic signal fee was required, but still determined that the city had discretion as to the nature and extent of what that fee would be, and found that that discretion was enough to entitle American Furniture to a hearing. And we ask this court to make that same finding here and finally give Contreras Farms the right to go to a hearing and have a neutral arbiter decide whether or not the city of Phoenix overstepped its bounds and imposed an unlawful and disproportional exaction. Thank you.
Thank you. Also, I thank you both for your interesting arguments and very helpful. We will take this matter under advisement and issue a decision in due course. The court will now take a brief recess to prepare for the next argument.